Thank you, counsel. Your time's expired.
Okay, thank you.
Next case is DORAN WOLFE versus MCNAMARA.
Oops.
Must be time to retire.
That's a sure sign. It's the one with the exhibits on it.
No, that's a late.
May it please the Court. My name is Theodore Doran. I am appearing on behalf of the appellant in this matter. The law firm at that time was called DORAN, WOLFE, ANSAY, and KUNDID, now known as DORAN, Sims, WOLFE, and KUNDID. There are essentially 5 issues presented. Oh, and I would like to reserve 8 minutes for rebuttal. There are essentially 5 issues that are presented before the Court, but there's really only one issue that's at the heart of the question that has been raised, and that is the question of whether or not a trial court in the state of Florida can enter an order affecting the priority of liens on property in a foreign state, in this instance, the state of North Carolina, and whether that Florida trial court can enter an order requiring the sale of foreign property, in this case in the state of North Carolina. The Court really need only look to the cases of Polkowski and Pollock out of the 4th DCA to resolve this issue. I would remind the Court, or suggest to the Court rather, that it is not incumbent upon the Court to reach a decision here as to how matters might be resolved in North Carolina, how the case might come out, whether or not the priority of liens in North Carolina would be resolved favorably or unfavorably to the firm. The only question for the Court here, in my view, is whether or not a trial court can enter an order that would directly affect those issues.
Tell me, Mr. Doran, how you compare whatever the relief you got from your client with a charging lien would be. Because I have to tell you, this looks for all the world to me like a charging lien, which would certainly be resolvable here.
But it's not a charging lien.
Why did you attempt
a charging lien is something that would be filed in the court at the trial court level here in Florida.
Isn't that what you tried to do?
No, sir. I never requested a charging lien.
Didn't you?
I'm sorry?
You attempted to intervene, didn't you?
No, sir. Let's be sure we're clear on this. My client, the firm's client, essentially was put in a position of wanting to appeal at the end of the case. The firm took the position that it would not continue to carry the fees unless she collateralized the fees in some way. The fees were then reduced to a note. The fees were no longer fees at that point, and the note was signed, and a mortgage was granted both on New Smyrna Beach property, which is not an issue in this case, and property in North Carolina. There was never an attempt to obtain a charging lien, ever. The motion to intervene only came...
I didn't say that there was an attempt to obtain a charging lien. I think what I said was, this looks for all the world to me like a charging lien.
Well, I would just respectfully suggest to the Court that if you look at what a charging lien is, it can't be one. I mean, a charging lien is something, as the Court knows, is addressed at the local level in the state court. It would be something that would be sought to, pursuant to a court order locally in the state court level. It's just merely a payment of fees.
How did your firm get involved in this case as a party?
We moved to intervene. We're still not involved in the sense that the motion to intervention was denied. We're still a non-party.
You attempted to intervene.
Yes, sir, because at the point in time that the emergency motion was filed, seeking action at the trial court level of the state of Florida to order a sale or affect the property, it required the firm then to step forward. Had that motion never been filed, the firm never would have raised the issue because the issue is properly resolved in North Carolina. If there was a question about the priority of these liens and about the sale of the property, that even given the final judgment as it's presently entered, that those issues would have to be resolved there. And North Carolina law is pretty clear on this, although, as I said, I don't think this court ever needs to get there. We did cite both the Buchanan case and the Kirsten case, which specifically says that North Carolina will give no good faith credit to a judgment from an outside state, in this case the state of Florida, in that regard.
Why did you attempt to intervene and inject the North Carolina issue into the case if the court has no jurisdiction to worry about North Carolina property anyway? I mean, what was the purpose of that?
Well, because there was an emergency order filed that was directly affecting our status in the state of North Carolina, so at that point we raised the issue. I mean, we could have stood back and, done nothing.
But the court ordered you to satisfy the mortgage, is that what it was? The court ordered you to satisfy the mortgage?
The firm, yes. The court ordered the firm to satisfy the mortgage, which, quite frankly, in our view, belies the whole point, which is that the court has no power to enter any order to resolve this real estate issue. In any other context in Florida, a court would not need to order anybody to do anything. It would simply enter an order changing whatever it is that it deemed appropriate in the title record, and we see that all the time in final judgments where the line is put in if a party doesn't sign.
I understand that with respect to the Florida property, but I'm more concerned about the North Carolina property.
Oh, of course, yeah, that's the only issue before the court.
I don't understand who objected the North Carolina property issue into this case?
The firm, with regard to the jurisdiction and the status of the priority of the liens, the firm did when it was served with the notice of the emergency motion to order a transfer or sale of the property to the husband because he was saying that he wanted to buy the property from essentially himself. The wife has long since gone bankrupt, and the trustee has abandoned the property, so she's not really a party in interest at this point.
Let's see, your secured interest was only on her half, correct?
Yes, sir.
I mean, that's all she could give you.
Yes, sir.
The husband wanted to buy the property, basically buy her interest, correct?
In fact, he wanted to buy it from himself and her interest out, yes.
I guess the proceeds would go to the bankruptcy trustee, is that what would happen?
No, sir, the bankruptcy trustee has abandoned the property because the value of the property and the amount of note were...
Who would get the money, him, get it back?
The family limited partnership, which is an important point. The husband here is not a party is not the party to whom the money would be paid.
Right.
The family limited partnership made the loan.
They made the loan, the original loan.
Yes, sir, and they did
on those properties, right?
Yes, sir, and they did so on an unsecured note. And they knew at the time that they had no collateralization, except to the extent that the note provided them with. Certainly in Florida, it being a race notice state, if you are on notice of the existence of the note, then you are required to recognize it, and I did so with regard to the New Smyrna Beach property. With regard to the North Carolina property, it's a completely different state of law. Now, when this happened, of course, both these properties were appraised at $1.8 million. There was $3.6 million of value. The economy changed all that, and everybody would have been paid out no matter what across the board. But what we're left with is the simple question of can a trial court affect the priority of liens on a foreign state property?
And the final judgment that was entered purported to do that, correct?
Oh, it absolutely did.
Your motion to intervene was so that you could challenge the validity of a provision of the final judgment.
Yes, sir, exactly. And we did.
Which was entered at the time that you were representing the wife.
No.
It was after.
No, it was well after. She was already in bankruptcy.
No,
and I was not representing her. I was not representing.
Okay. When you represented her, did you deal with the North Carolina property as part of the divorce?
Yes, but now,
What way?
well, it
Did you
was,
take the position that the court had no jurisdiction, or did you deal with it as if the court had jurisdiction?
no, let's be clear about this. The court absolutely had jurisdiction to resolve title to the property based on the prenuptial agreement,
And
which
the prenup-
specifically,
They had a prenup, you challenged that, court found it was valid.
That's right.
It said they each get 50/50, right?
that's because that's exactly word for word what the prenuptial required the
Right.
court to do.
Does the trial court in a divorce case have the authority to order parties to sell a piece of property that's outside of the state?
Absolutely not.
How do you deal with the Gill case out of the 3rd DCA, which
versus Mendelsohn.
ordered the parties to sell a piece of property in Israel, to list it, to sell it, and to distribute the proceeds?
The Gill versus Mendelsohn case flies directly in the face of Polsky, Pollock, Salmons, Farley, Wentworth, and O'Hara. It is a direct conflict, and it's bad facts make bad law, but it doesn't apply here anyway, because clearly in the Mendelsohn case, it was a function of equitable distribution. The basis, if you read the Mendelsohn case,
Well, the
is...
question is whether the court has jurisdiction to order the parties to do something vis-à-vis a piece of property in a foreign jurisdiction, right?
In Israel, in that
Whether
case.
it's in a divorce case or it's in a partition case, does it make any difference for the jurisdictional purpose?
Yes. The
Okay,
court
so
does not have subject...
If a partition action were brought in Florida
Yes,
to
sir.
divide up various properties and one of the properties was in another state,
Yes, sir.
would the court have jurisdiction to order partition of the property in a foreign state?
Absolutely not, and in
It
fact...
doesn't matter whether it's a divorce case or it's a partition case, the same rule applies.
Yes, sir. And in
The
fact...
distinguishing factor of Mendelsohn, which is it involves partition, is really irrelevant to whether or not, I mean, you're not saying, you can't say this case is distinguishable, you have to say this case is wrong and it shouldn't be followed.
I just did say it was wrong, and I also would say it was distinguishable in the sense that the Mendelsohn case specifically refers to the equitable distribution as the basis for
And is
the
it at odds with
decision.
cases from our district?
I'm sorry?
Is it at odds with cases from our district, or is it only at odds with other districts such that we have to resolve which of two to follow?
The 5th District has not, addressed this issue at this point. But I want to make a point with the court that in fact in this case, there was an attempt to partition both Atlanta, Georgia property and the North Carolina property, and the trial court at that point, back in 2006, questioned whether he had the power, and in fact, counsel for the husband specifically wrote a letter which is found at tab 1 of my addendum, which says, where he says, he concedes that the court has no power to do this. And then separately and apart from that, counsel for the husband filed a brief citing the very cases that I'm citing now for the proposition that no partition action could be sustained on the North Carolina or Georgia property in the state of Florida.
Let me go back so that I understand your role at the time you were representing the wife in the divorce. Go
Let me
ahead.
ask you, it goes to that. When the final judgment of dissolution was entered, did you represent Mrs. McNamara?
Yes.
When you told Judge Palmer, you were talking about this order. When this order was entered, you didn't represent her.
Oh, yes, right, yes.
But at the time the final judgment was entered, you were representing the wife.
Yes, I was.
At that point, did you take the position that this provision of the final judgment was beyond the jurisdiction of the court or invalid?
I did not.
Don't you see a problem with coming back later and trying to challenge the judgment that you represented her in getting entered?
I do not, to the extent that the law is very clear, jurisdiction is always the subject
Why wasn't it
of...
raised when you were representing her before the judgment was entered?
Well, first
if
of all-
you're representing her and your position is the court doesn't have jurisdiction to deal with this property, do you have some obligation as a lawyer to tell your client, this is invalid, there's no jurisdiction here?
Yes. First of all, there was no notice to me or the firm that this was going to be the ruling. The ruling came out, and that was it. I did not file a motion for rehearing on that issue.
Did you argue to the court that they didn't have jurisdiction over the North Carolina property?
For sale and partition?
For any purpose? What was your argument to the trial court as to what they should do with the North Carolina property?
That he should do what he did, which was create tenants in common pursuant to the
Okay, so the provision of the final judgment that you're now challenging is invalid is exactly what you asked the trial court to do when you were representing the Welfare.
No, Your Honor, absolutely not.
And what did you ask the trial court to do, and how did that vary with what the final judgment did?
Simple. The prenuptial agreement specifically provided for the trial court to divide the property by announcing that the tenants by the entireties would be tenants in common. And within personal jurisdiction, the trial court in Florida absolutely has that power over foreign properties. What the trial court went on to do, which was not something that I argued, nor was I anticipating, was to order sale, was to order the priority of liens and those types of things, which was not something that was an issue.
The court didn't rule on the priority. It just said you got to satisfy the mortgage.
No, Your Honor, not at all. In fact, the court ordered that the money be paid to an unsecured note, which is unrecorded. So that is directly affecting the priority of the liens in North Carolina.
I thought what he said was you got to satisfy your mortgage, which would have, be the same.
But that was later.
Yeah, okay.
Yeah. At the time the judgment was entered, the order was you shall apply the proceeds to this unsecured note, which is, just that. It is what it is. And under North Carolina law, it is what it is. And
at that point in time, you didn't have your mortgage, is that correct?
You did.
Or you did have your mortgage?
I did not have a mortgage at the time the final judgment was entered.
Okay, so the final judgment was entered which said, sell this property, apply the proceeds to this unsecured note.
That's
you
right.
knew there was a judgment calling for the proceeds to be applied to the unsecured note. You then put your mortgage in place, which thwarted the ability of the final judgment to be carried out, correct?
That is not true.
Did your mortgage prevent the final judgment from being carried out because it prevented the monies from being applied to the unsecured note?
Ultimately. But at that time, there was more than enough value in the properties that it wouldn't be an issue. So there wasn't a thought process at that point in time. It's only because the property values fell.
You didn't take a second mortgage and say, I'll be behind the unrecorded note, right? So that if there's enough money there, I'll be paid. You took the position, I'm going to get in first position, and therefore, if there's not enough money, you're going to get paid rather than what the trial court ordered to be paid at the time of the final judgment, right?
Which was void ab initio, because that was determining the priority of liens, and that's the decision that has got to be made in North Carolina.
At the time you were representing them when the final judgment was entered, or did you argue to the court this is void ab initio?
No, not later. Well, yes, I raised it when there was a motion.
A year later.
An emergency motion, yes, that's right.
It wasn't an appeal, there was no appeal, there was no argument for an appeal for that, right?
No, but jurisdiction is just that. You either have it or you don't, and the trial court clearly did not. And even if this court were to find differently, the North Carolina court could look at it and say, I give no full faith and credit to the issue because it resolves an issue at North Carolina with regard to our property. It's an in-line proceeding. You can suggest that it was what it was, but it is the law. I followed the law in every respect.
You're down to about 2.5 minutes for rebuttal.
May it please the court, my name is Terry Young. I'm here on behalf of Dennis McNamara. This has been a long case. It started in Judge Palmer, you've been on, this is your third appeal. It started in November of 2005. The final judgment wasn't affirmed by this court until, I believe it was August of 2010.
Was there an appeal from the final judgment?
Yes, there was an appeal, and taken by Mr. Doran. And one of the points that the court raises is he was counsel of record when the final judgment was entered. He tried these issues about North Carolina by consent. We've put them in our brief. We've quoted his pleadings where he asked for equitable distribution of all of the property, including North Carolina, and the New Smyrna Beach properties. They acknowledged that the debts were joint. There were stipulations that were very important that were filed in the court authorizing this court, and the stipulations did a number of things. The stipulations are in a brief. First of all, the stipulations said that the promissory notes on North Carolina and New Smyrna recognized that the property were pledged for them, unrecorded but pledged. Secondly, they waive any and all available defenses to the enforceability of the promissory notes and stipulate that the notes are valid, binding, and enforceable marital obligations of the defendants in accordance with the terms of the promissory notes, which are duly owing to the third-party family limited partnership of his father. Then they go ahead and say that the defendants are jointly and severally liable for them. They go on and say that the fees in the Orange County case that the family limited partnership incurred will be apportioned by the trial court in the divorce court. And then they agree that they won't obtain financing or do anything to affect the priority of these notes on these properties going forward, and induce the family limited partnership not to attempt to enforce these notes, and the family limited partnership agrees to not collect them. Mr. Doran enters in that stipulation in Orange County. That stipulation is added and adopted by Judge Breeze in Volusia County, and we tried the case on that, and ultimately, after the prenuptial agreement is upheld, the only issue ultimately was whether, for equitable distribution, are these two properties in the notes. And Judge Breeze had in personam jurisdiction. This issue was tried. It was part of closing argument on both sides. They never raised this issue. They never objected to it. I actually asked in closing argument, because they were going to become tenants in common. Up to now, there could be no execution of a note or mortgage because they're by the entirety. I argued and asked Judge Breeze to award the property to my client and have him sell them and account for the proceeds, because that would have avoided any tenants in common issue. Nowhere did anyone ever imagine that there would be a blatant violation of this stipulation by the recording of a note in mortgage months after the final judgment.
How was it a violation of the stipulation?
Well, the stipulation represents to the family limited partnership and everybody that we're not going to do any financing or do anything to encumber this property. And that's just what they did. And 2 months after the final judgment, they directly, and it's undisputed, Mr. Doran, with his now partner, Mr. Sims, prepares a note and mortgage and tells his client to sign it without any counsel to secure his fees. At the June 10, 2010 hearing, where Judge Breeze called this nothing more than a charging lien, and Mr. Doran did not object.
I would object to the use of demonstrative aid. I've never seen. I have no idea.
This is right out.
Did you file to use demonstrative aids? No. We have a rule here.
Okay. I won't use it then, but I'll read to you from the court. It's in the record of appeal. At the same transcript on June 1st, earlier in the transcript on page 29, which is at volume 18, 743 in the record of appeal, Mr. Doran, in explaining to Judge Breeze, he still represented her. He still represented her on June 10, because I had subsequently found out about his note and mortgage when we went to collect our $280,000 fee judgment against Ms. McNamara. And we're about to sell the New Smyrna house, and I learn of this mortgage and note that's going to impair the ability to comply with this section of the final judgment. And he explains to Judge Breeze why he did it. And he doesn't limit it to New Smyrna. He later now, after he withdraws from her, and she files bankruptcy in 2010, changes and says, well, I abided by it to New Smyrna because the court had jurisdiction over Florida, but didn't have jurisdiction over North Carolina.
At some point, Judge Breeze said, this isn't a violation of the judgment. Because
it hadn't happened yet.
Was that at this hearing?
Yes.
Okay.
He said it hadn't happened, and Mr. Doran says...
what hadn't happened yet?
He told the judge, the seller complaining about that's about to occur in New Smyrna, I'm going to execute my release of my deal because I'm not entitled to...
The taking of the mortgage, the judge didn't find to be a violation.
Not yet. He said it could be if he doesn't release it. But this is what Mr. Doran said to Judge Breeze, explaining why he recorded these. Everybody's trying to grab whatever piece they're entitled to under the law in accordance with priority, and that's exactly what's going on here. But you said at the hearing, Mrs. McNamara still owes me money, and she does. But I said to her, and he made reference to this just a moment ago, quote, I want some security before I move forward with her appeal. And if you want me to continue to represent you, I want a mortgage on these properties both properties, North Carolina and New Smyrna, and I want to take a position on the properties in accordance with the law so that whatever, if any, interest you retain in these properties, I'm going to be paid the money as opposed to you, and you know towards fees. So he explained to Judge Breeze at the time, before, this was when he still represented her, that the only reason he did it was to perfect, in essence, a charging lien, as Judge Breeze recognized it was. Now, very important, Judge Palmer.
If this is not deemed to be a charging lien, just for hypothetical purposes, would the court have any authority or jurisdiction to order the attorney to do this in light of the fact that the motion to intervene was denied? So
yes.
The law firm is not a party to the proceedings at this point, correct? What's the authority of the trial judge to order them to do what he ordered them to do if it's not deemed to be a charging lien?
First of all, he had jurisdiction of the Doran law firm at the time he entered the order in question, because at the time the order in question, Mr. Doran had filed a motion to intervene. The case law that we've cited, in the Supreme Court case law we cited, says if you subject yourself to jurisdiction by filing a motion to intervene, it's not limited to the motion to intervene, but also claims that can be made back against you related to that. And also the judge, in his final judgment, retained jurisdiction for all purposes to enforce his order. We've cited in our briefs that trial courts have inherent jurisdiction to enforce their orders.
Over anybody? I mean, what if she had given a note to a third party who knew about the lawsuit? Could he have ordered that third party without making that third party a party to the lawsuit?
We don't have those facts here.
No, but you said retain jurisdiction over everything, and that's the basis on which but he doesn't retain it over non-parties, does he?
Well, at the time that this note was entered, Mr. Doran was counsel of record, number one. Number two, to answer your question, what actions did Mr. Doran on Ms. McNamara take that was inconsistent with his contention now that he's not counsel of record with respect to the North Carolina property? I'll tell you what he did. Number one, the final judgment in paragraph 31A through F says you have to list realtors, etc. He filed on her behalf a notice of a selection of a realtor, Terry Potts in North Carolina. Then it says you have to sign a listing agreement. He filed on her behalf in front of Judge Breeze a notice that they had of the listing agreement. They have to pick a purchase price. He filed in the court, and it's in the record of appeal, that they accepted the purchase price. We had 2 or 3 hearings on whether or not she complied with doing various things with respect to the North Carolina property, including Judge Breeze entered an order that she couldn't get a commission on the North Carolina property. She was a sales agent here. He filed a motion challenging Judge Breeze's jurisdiction to enforce paragraph 31 of the final judgment. Judge Breeze said he had continuing jurisdiction to enforce the order of his final judgment. They didn't appeal it. They filed a motion for a hearing. It was denied. They didn't appeal it. Judge Breeze filed a motion for entered an order of clarification in January of 2009 saying that all of the proceeds on North Carolina and New Smyrna would have to be in and no money could be dispersed until such time as all the money had been collected. He didn't appeal that. He did file a motion for a hearing on her behalf. He didn't raise this issue. He took an appeal before this court. He didn't raise this issue. Importantly, there were 2 credits that Mr. McNamara was awarded out of these sale proceeds. One was to North Carolina. One was to New Smyrna Beach. You might remember, Judge Palmer, the court reversed on one issue that Judge Breeze's final judgment, and that was the credit to New Smyrna because Mr. McNamara agreed to provide a marital residence to her, but didn't reverse because it wasn't raised that he wasn't entitled to a credit on North Carolina. Once again, this was tried by consent. Not only was it tried by consent, the Gill versus Menderson case is right on point. They concede in their brief the Farley case, 797 2nd, 4th DCA, 2001, where the court held that an order by an out-of-state court having personal jurisdiction would be entitled to full forcing credit. And in the Farley case, it cites to the 5th District Court of Appeal. There is no case right on point having to do with this, but it's common in divorce cases where people have in personam jurisdiction. They try these issues by consent. A final judgment is entered, and in this final judgment, it clearly says, beginning at paragraph 30, that the properties is marital property and marital debts pursuant to the stipulations and orders related to same entered into by the parties and the court, all signed by Mr. Doran on behalf of his client.
Are Polkowski and Gill distinguishable, or just that's a conflict? And
I think they're distinguishable, because in the Polkowski case, they say it was tantamount to an in rem proceeding where there was no partition. We don't contest. There was no partition claim for North Carolina. There didn't need to be, because the parties consented to that asset as being subject to equitable distribution. Specifically, they raise in their own pleading that is a, let me find it right here. I'll read you what they say in their pleading. That was the subject matter. The former wife's amended petition. This is one that was adopted by Mr. Doran when he came into the case replacing Baker and Hostetler. Quote, equitable distribution. During the course of the marriage, the husband and wife acquired certain assets, including real and personal property under joint ownership. There's only two, or otherwise as marital assets, and the court should equitably distribute same. We admit that, and we specifically reference the two properties and the debts in question. They contended at the time that the debts were not really debts, but later conceded that via the stipulations, and thus that's what happened at trial. Nowhere is this ever raised until Mr. Doran changes.
Can I interrupt for a second?
Yes, sir.
Can you tell me, please, at what point was the North Carolina property, at what point did it become a tenancy in common?
Upon entry of the final judgment of dissolution of marriage on August 8th, 2008. I remember that very clearly. That happens to be my birthday.
Well, happy birthday. Now, there was an appeal taken from that final judgment?
There was an appeal taken by Mr. Doran of the final judgment.
When was the appeal resolved, and did that have the tendency to extend the time at which they held it jointly rather than as a tenancy common?
I don't believe it extended the time because they didn't appeal the dissolution of the parties' marriage.
Just the...
they appealed the prenuptial agreement aspect, and they appealed an accounting aspect.
Well, the prenuptial agreement said it was going to be tenants in common, right?
The prenuptial, they appealed the upholding of the validity of the prenuptial agreement.
Right, but that said they were going to hold it as tenants in common.
The prenuptial agreement provided any property would be treated as it was titled, and it was titled jointly, so under Florida law, it would be equitably distributed.
At what date did Mr. Doran acquire the note and mortgage?
He acquired the note he acquired, as I recall, and I have a timeline here, but it was late September, after the judgment was entered in 2008.
Okay,
and then
so if the property was held as tenancy in common at that point, she had a right to mortgage that property.
Theoretically, she had I disagree, Your Honor. I believe that for her to do so knowingly, with advice of her lawyer at the time, frustrated and impeded the final judgment in the equitable distribution scheme by Judge Breeze, and also violated the letter, if not the spirit, of the stipulations by, in essence, encumbering the property that the Family Limited Partnership had agreed they would forego collection on.
They had a note, but they hadn't recorded it in North Carolina?
No, they relied upon the stipulation of a lawyer and the stipulation and the order affirming it. That's what they did. Yes, sir.
The family trust, it was a recordable note. They could have recorded it in North Carolina?
I guess you can record anything, but it wasn't a mortgage. No, sir. No, sir. Yeah, if the Family Limited Partnership did anything wrong, they relied upon the word of Ms. McNamara.
They had a note. They didn't have an unrecorded mortgage. There was no mortgage at all.
There was no mortgage. It was just a note, and the note specifically says, as recited in the stipulation, there was a separate note, and it said, which we pledged this property. There probably could have been an equitable foreclosure, but there wasn't. So, and also I would point out that on this issue of jurisdiction, Mr. Doran, in his initial brief on page 3, admits that there's jurisdiction on North Carolina. It says Doran, WOLFE, ANSAY, KUNDID acknowledges the lower court properly exercised jurisdiction over the North Carolina real property for one purpose. He only objects for another purpose, the equitable distribution scheme, because it now beginning in 2010, when she filed for bankruptcy and he withdrew, and he seeks to intervene to set aside a portion of the judgment that he never set aside on behalf of his client's own interest. He wants to set aside for his own best interest. Remember, this is a case where the court denied any additional award of fees to the wife, awarded fees to the husband. She wasn't going to get, and now the property is underwater. Mr. McNamara, we had several hearings on Mr. McNamara's previous offers, and Judge Brees said, no, not yet, we're going to see if it sells. Finally, after it hadn't sold for years, he made this offer in excess of the appraised value in accordance with the scheme set out by Judge Brees. It was approved by the former wife and her attorney, the bankruptcy lawyer, Mr. Bernard from Fernandina Beach. She filed a paper in response to our motion requesting that this relief be granted and that intervention be denied when it was filed 33 months after the final judgment, 20 months after the appeal had been disposed of, or 20 months after the motion for rehearing had been disposed of, 9 months after the appeal had been disposed of, and 8 months after the mandate had been disposed of. They filed consent and wanted that Mr. Doran to execute the sole document that he failed to execute that would allow this matter to go to closing as ordered by Judge Brees. He did the same thing in June and July of 2010 on the New Smyrna property, but he now conveniently says, I only did that because the court, of course, had jurisdiction over New Smyrna, and I recognize that my mortgage in New Smyrna was really only a charging lien, and I wouldn't be entitled to any money under Judge Brees' order. Of course, he did so at the time to avoid being held in contempt.
Did he actually say that the mortgage on the New Smyrna property was a charging lien?
He didn't say it except what I just read to the court, where he said the reason he did it, and Judge Brees later said, this is nothing more than a charging lien, and he never refuted that, and he subsequently, within a month, executed a document releasing it, wrote a letter, and I quoted the letter in our brief.
But he says that's because it's a notice date, that he knew about the first lien.
Well, he hadn't raised that at the hearing. At the hearing, I just read you what he said. He said these properties.
He said that today, I think.
Well, he said that today because the position has changed. Okay. Today, what's now happened since then, she filed for bankruptcy. He withdrew. She discharged his claim for fees. Right. He was denied any award of fees, and he's going, uh-oh, I better change my tune. So he files a motion to intervene for the sole purpose of challenging the disposition of the North Carolina property never raised before. It's highly inappropriate. It shouldn't have been done. It shouldn't have been done that he counseled his client at the time to execute a note and mortgage that contradicted the spirit and the intent of the stipulations and directly interfered with Judge Brees' equitable distribution scheme. Directly interfered with it. Inappropriate for counsel of record to do that. Inappropriate to then resurface now and attempt to foster or to prosper for his own advantage. Because what will happen now, if the court does not affirm Judge Brees and Judge Brees cannot order him to do what Judge Brees is ordered to do, I guess they'll foreclose on the property and Mr. Doran will get it all. And there'll be no money for Mr. McNamara to pay the Family Limited Partnership, which is a separate third-party entity. And it would be a miscarriage and travesty of justice. I think I've used all but 20 seconds. Is there anything I missed or any other question I can answer? Because there's a huge time frame of this case.
Not in 15 seconds, sir.
Thank you.
Thank you, Your Honor.
Was there a mortgage on the New Smyrna Beach property, and that's why you gave up your claim on there because some first mortgage got it all, or
no, sir. I gave up my claim on the first.
Wasn't it? It's the same note. The note was unsecured in the legal sense, right. But you recognized that was pledged, and you had notice of it.
I had notice of it.
You said I'm a second position.
Any third party could have come and bought that property and ignored that note without knowledge of the existence of the note. Of course, I knew the note, but let me say.
But the law is different in North Carolina, and that's why
Your Honor, I just have to say this.
note there.
I'm sorry.
Right? the law is different in North Carolina, so your position is I don't have to recognize the priority of the note in North Carolina, even though I had to recognize it in Florida.
First in time.
My position is let North Carolina decide that, but yes, I mean, I'm not being cute about it, I'm just saying that is a decision for North Carolina to make. But I want to say out loud, I emphatically never, ever suggested this was a charging lien. In fact, this same hearing that he's showing this little language over, which I totally embrace, Judge Breeze was so annoyed with him arguing the spirit intent argument he just gave you that he ordered him to pay me $4,000 in legal fees at the end of that hearing. That's what I have been dealing with. These misrepresentations and these demonizing of the attorney or the people as opposed to addressing the issue has caused this case to be what it is and the $500,000 fee that ultimately came out of it. I have never misrepresented anything to the court. I've never violated any law. I don't care what you look at. The stipulation specifically says that she would not subordinate or otherwise jeopardize in any way the priority of the notes. The notes had no priority. And if you think about it, how would anybody do that as a matter of law? You know, if you had a mortgage on your house, how could I change that? It's recorded. Or it's not. It's either recognized by law or it's not. Nothing was violated in the stipulation. If they wanted to make a condition of the settlement of this case, that she sign a mortgage in North Carolina, that was something that could have been considered, but that's not what they did. And the law is the law, the language is the language, and this reference to equitable distribution, look at paragraph 21 of the prenuptial agreement. What Mr. Young refuses to acknowledge is that paragraph 21 of the prenuptial agreement specifically provides the parties agreeing that there will be no equitable distribution. That's what it says. That's what it says.
Thank you, counsel. Your time's expired.